negligible differentia, forming the basis of the classification on which the impugned amendment is entirely premised. To that extent, the amendment is constitutionally indefeasible. However, excluding a large section of the equally poor and destitute individuals based on the social backwardness and legally acknowledged caste stigmatization from the benefit of the new opportunities created for the poor, the amendment practices constitutionally prohibited forms of discrimination. The overarching principles under Articles 15.1, 15.2, 16.1 and 16.2 is that caste-based or community-based exclusion, that is the practice of discrimination, is impermissible. Whichever way one would look at it, the Constitution is intolerant towards discrimination and untouchability in all forms and manifestations which are articulated in Articles 15.1, 15.2, 16, 17, 23, and 24. It is prohibits exclusion based on past discriminatory practices. The exclusion made to the other than exclusionary clause negates these principles and strikes the heart of the Equality Code, specifically the non-discriminatory principle, which is a part of the core of the Constitution. The Sinha Commission was set up. The Sinha Commission was set up to examine the condition of economic backward and suggested measures, including the feasibility of reservations, to improve their law. The report published in July 2010 is based upon the census of 2001 and later surveys. The statistics NSSO 2004-2005, which the report is based on, disclosed that in all 31.7 crore people were below the poverty line, BPL, of which the scheduled caste population was 7.74 crores. That is 38% of the total of the scheduled caste population in the country. Scheduled tribe population was 4.25 crores, that is 48.4% of the total scheduled tribes of the country. 13.86 crores of OBC population, which was 33.1% of the total OBCs, and 5.85 crores of the general category, which is 18.2% the total general category. These facts established that the bulk of the economically weaker sections of the society belong to the classes described in Articles 15.4 and 16.4. I pass on to question number 2, which is that unaided private institutions, including those imparting professional education, cannot be seen as standing out of the national mainstream. As held in Committee and Society for Unaided Private Schools, reservations in private institutions is not per se violative of the basic structure. Thus, reservations as a concept cannot be ruled out in private institutions where education is imparted. They may not be the state or state instrumentalities, yet the value that they add is part of the national effort to develop skill and disseminate knowledge. These institutions, therefore, also constitute material resources of the community, in which the state has a vital interest and are not merely bodies set up to further private objective of their founders, unlike in the case of shareholders of the company. Therefore, I hold that on question number 2, the amendment is valid, but for reasons of answering question number 3, the amendment has to go. Before I sum up, I wish to address one point which the majority has dealt with, but more as a note of caution, because it is not necessary for me to deal with that aspect, which is the 50% cap. It is pertinent to note that the breach of the 50% limit is the principal ground of attack of the 76th Constitutional Amendment, 1994, which is inserted as entry 257A. The Tamil Nadu Backward Classes, Scheduled Caste and Scheduled Tribe Reservation of Seats in Educational Institutions under the State Act 1993. The validity of that enactment and whether the inclusion by the Constitution Amendment violates the basic structure is directly in issue in a batch of cases pending before this court. The view of the members of this bench constituting a majority that the creation of another class which can be a recipient of up to 10% of reservation over and above 50% committed under 15.4 or 16.4 in my considered opinion therefore has a direct bearing on the likely outcome in the challenge in that proceeding. I would therefore sound this cautionary note, since this judgment may well seal the fate of the pending litigations without the benefit of hearing in those proceedings. The last reason why I find myself unpersuaded to agree with the opinion that the amendments, by creating a different kind of criteria, have to be viewed separately, and that Indira Sani was confined to reservations under 15.4 and 16.4 is because permitting the breach of the 50% rule, as it were, through this reasoning becomes a gateway for further infractions, which in fact would result in compartmentalization. The rule of reservation could well then become the rule of equality or the right to equality, could then be easily reduced to a right to reservation, leading us back to the days of Champakam Durai Raja. In this regard, the observations of Ambedkar have to be kept in mind that reservations are to be seen as temporary and exceptional, or else they could eat up the rule of equality. The fraternal principle, I'm now summing up, the fraternal principle is deeply embedded to this nation's ethos and culture. The specific provisions which form part of the Equality Code are inextricably intertwined with fraternity as well. It is fraternity and no other idea which acknowledges that ultimately all individuals are human beings born through the same natural process, subjected to the same physical limitations, and finally leave this world at an unknown time but are sure to live. Fraternity is a concept awakens humans to the reality that despite our apparent or superficial differences, ethnic, religious, caste, gender, origin, or economic status, the institutions we create need our collective cooperation and individual commitment. Every social order invariably contains individual differences, be grounded on ethnicity, wealth, talent, or realization of one's abilities. The diversities abound. The idea of fraternity is to awaken to the consciousness of each member of society that our institutions which are created, the ideas that we develop, and the progress that we wish to achieve cannot be in isolation, by separation, but with cooperation and harmony. On this, I want to highlight the words of two social reformers, which demonstrate that the principle of fraternity and the ideas and values connected to it are not new, but in fact transcend time. Swami Vivekananda's message in his address to the World Parliament of Religions in Chicago on 11 September 1893 has the theme of universal brotherhood of all. The differences in religion, the exclusion of one of other would fade. He evocatively said, if anybody dreams of the exclusive survival of his own religion and destruction of others, I pity him from the bottom of my heart and point out to him the banner of every religion will soon be written, in spite of resistance, help and not fight, assimilation and not destruction, harmony and peace and not dissension. Aurobindo too was conscious of the need for fraternity. In a speech delivered in Howrah in 1909, he presciently said, again, there is fraternity. It is the last term of the gospel. It is the most difficult to achieve. Still, it is a thing towards which all religions fall and human aspirations rise. There is discord in life, but mankind yearns for peace and love. This is the reason why the Gospels will preach brotherhood, which preach brotherhood, spread quickly, and excite passionate attachment. This was the reason for the rapid spread of Christianity. This was the reason of Buddha's spread in the country and throughout Asia. This is the essence of humanitarianism, the modern gospel of love for mankind. None of us have achieved our ideals, but human society has always attempted an imperfect and limited fulfillment of them. It is the nature, the dharma of humanity, that it should be unwilling to stand alone. Every man seeks the brotherhood of his fellow, and we can only live by fraternity with others. Through all its differences and discords, humanity is striving to become one. Summary of findings in questions 1 and 3. On question 1, it is held that the state's compelling interest to fulfill the objectives set out in the directive principles through special provisions on the basis of economic criteria is legitimate. That reservation or special provisions have so far been provided in favor of historically disadvantaged communities cannot be the basis for containing that other disadvantaged groups who have not been able to progress due to the ill effects of poverty should remain so, and the special provision should not be made by way of affirmative action. Therefore, the special provisions based on objective economic criteria is per se not violated. However, in answer to question 3, I highlighted the framework within which has been introduced by the impugned amendment by excluding backward classes. According to me, this is violative of the basic structure. A universally acknowledged truth is that reservations have been conceived and quotas created through provisions in the Constitution only to offset fundamental, deep-rooted generations of wrongs perpetrated on entire communities and castes. Reservation is designed as a powerful tool to enable equal access and equal opportunity. Introducing the economic basis for reservation as a new criterion is permissible. Yet, the othering of socially and educationally disadvantaged classes, including SCs, SCs, and OBCs, by excluding them from this new reservation on the ground that they enjoy pre-existing benefits, is to heap fresh injustice based on past disability. The exclusionary clause operates in an utterly arbitrary manner. First, it others those subjected to socially questionable and outlawed practices, though they are amongst the poorest sections of the society. Secondly, for the purpose of new reservation, the exclusion operates against socially disadvantaged classes and castes absolutely by confining them within their allotted reservation quotas. Thirdly, it denies the chance of mobility from reserved quota based upon past discrimination to a reservation benefit based only on economic deprivation. The net result of the entire exclusionary principle is Orwellian, so to say, which is that all the poorest are entitled to be considered regardless of their caste or class, yet only those who belong to other classes or castes would be considered, and those from socially disadvantaged classes would be ineligible. Within the narrative of the classification jurisprudence, the differentiator or marker distinguishing one person from the other is deprivation alone. The exclusion, however, is not based on deprivation but social origin or identity. This strikes at the essence of the non-discriminatory rule. Therefore, the total and absolute exclusion of constitutionally recognized backward class of citizens is nothing but discrimination, which reaches to the level of undermining and destroying the equality code, and particularly the principle of non-discrimination. Therefore, on question 3, it is clear that the impugned amendment and the classification it creates is arbitrary, results in hostile discrimination of the poorest segments of society that are socially and educationally backward and are subjected to caste discrimination. For these reasons, Articles 15(6) and 16(6) are struck down and held to be violative of the Equality Code, particularly the principles of non-discrimination and non-exclusion, which form an inextricable part of the basic structure of the Constitution. While this reasoning is sufficient to conclude that Article 16(6) is liable to be struck down, there are additional reasons elaborated in Part 5, due to which this court is compelled to clarify that while the economic criteria per se is permissible in relation to access to public goods under Article 15, the same is not true of Article 16, the goal of which is empowerment through representation of the community. For the above reasons, it is hereby declared that sections 2 and 3 of the Constitution 103rd Amendment Act 2019, which inserted clause 6 in Article 15 and clause 6 in Article 16 respectively, are unconstitutional and void on the ground that they are violative of the basic structure of the Constitution. The writ petitions are consequently disposed of. It would be in order to place my gratitude and appreciation for the valuable assistance rendered by all counsel and all the counsel assisting them.
I have concurred with the view taken by Honorable Justice Ravindra Bhatt in its entirety. So effectively, the decision is 3-2.
So immensely grateful to your Lordship.
We are expressing a deep gratitude for the assistance rendered by every one of you in whatever capacity as the lead counsel, as even as nodal counsel. These two counsel did an excellent job. So it was a great learning experience for all of us, and this I express gratitude on behalf of all the members who are part of this bench. My colleagues also join me in expressing that. Thank you so much.
Immensely grateful.
Pleasant bench, not a pleasure to argue before your Lordship. Greatly obliged.
We are grateful for your Lordship's to accommodate and hear everyone. We are very grateful for that, your Lordships.
The operative portion will be like this. In view of the decision rendered by the majority consisting of Honorable Justice Dinesh Maheshwari, Honorable Justice Bela M. Trivedi, and Honorable Mr. Justice J.B. Pardiwala, the challenge raised to the 103rd Amendment to the Constitution fails. The writ petitions and other proceedings filed in that behalf stand disposed of accordingly. Thank you.
Grateful to you.
Grateful to your Lordship.
Sir, may I also thank the bench for a very patient and
It
very
was a great learning experience, Dr. Mohan Gopal.
grateful.
Grateful.
Please, Your Lordship. But my first respectful submission, and that if accepted, my Lord, you may save your Lordship's time, that the reference itself was not required. And I'll make that good, my Lord, without wasting much of the time. My Lord, kindly have a look at the reference order, my Lord. Your Lordships would find in my volume 1.
Let's keep the original volumes because maybe we have marked the volume. Just see, it will be convenient for us to look at there because we marked that volume.
I'm sorry.
Now, while
I'll, my
two
Lord.
volumes will create its own
My Lord,
effort for us.
Yes. And my Lord, some of the judgment which my learned friend did not sign, which I'll show from my volume, because there your Lordships have not seen.
Honestly, I think the arguments have gone beyond what is the reference, what is the issue before us.
No, that's what I want to show.
No, but we are confined to the issue only. As you said, so we did not let any argument take place beyond that. We also did not let the other points, you were apprehensive about some of the other points evolving and because of one more council appearing, we did not permit all those.
No, certainly, Manan. I will not.
Let me rephrase what I have in mind and
My
discuss it. I will say on behalf of the bench. There is a protection provided to the officers. That protection in one form or the other continued for a long period of time. Ultimately, the statutory provision was struck down on the short ground that it was discriminatory, not that it was bad in law.
My lords.
Grant of protection per se was not held to be bad in law. What was held was you cannot give protection to one group and not give protection to the other. This is the limited issue on this. Now, some hiatus period occurred, ordinance was issued, and then you brought in a legislation to cure the defect which the court pointed out by giving limited protection to certain categories. Chapter is over. Now, to some extent, it's theoretical in nature because what would happen for the interim period, how many cases they pointed out last time in some affidavit, it was stated that the number of cases were 100 odd or something, out of them some may be also over. But let's look at the facts of the petitioner. He was protected. No difficult. Because of his judgment, he became unprotected. Now, because of the other judgment, does he become protected again? So he says, as far as I am concerned, I am still protected merely because the protection was lifted for some period of time. It should not damage. And to our mind, one of the most crucial aspects is, it was not merely a reenacting of legislation which took place, where it was held that this legislation was bad in law, but on the ground of a particular defect. Which defect stands cured? Would you agree that this is the position? It's the only issue before us.
But may I say, Malad, without touching the.
Except one aspect, Mr. Datta said, which I find some force, which is a larger issue, he says, for us to say, not in specifically this case, that when such provisions struck down, he says, look, the court must give some guidance how to operate. So, if it is prospective, the court specifically says it is prospective. If it is to apply retrospectively, it is not said. So, some scenarios maybe, it's a general observation, may be taken into account of the consequences when a
provide applications for intervention or implement in Vivek Sharma versus Union of India. It is hereby made clear that they can assist the court when the matter is argued with regard to the constitutional validity of the law. That apart, their individual grievance may be dealt with by the Constitution bench, keeping in view the ultimate decision of the larger bench, or if it is otherwise possible, the instant petitions are accordingly disposed of, all pending interlocutory applications are also disposed of. And then one of the petitions is rendered justly infructuous, the last one. It is submitted by Mr. Puneet Jain, learned counsel for the petitioners, that the writ petition has become infructuous. This is because cooperative banks were extended a facility which they were not given earlier by a notification, etc. They were allowed to make the deposit. So therefore, this petition, which was filed by the Jain Cooperative Bank Limited, etc., had become infructuous. So that was closed. The other petitions, including mine, were referred to the Constitution bench, as you have seen. Interventions were allowed to be filed to assist on the constitutional validity of the law. Now, this is the state, your lordships may just note, as far as the orders of this court are concerned. Now, there are a couple of things which I should just mention to you. the Attorney General made a statement on this day, which is actually reported, it's not recorded in the order, but I'm just for completion, indicating on the 3rd of November 2017, where he, and we have at page 84 of the same compilation, there's a news report, but I'll just summarize it for you. The difficulty was that once this new act came, the holding these currency notes became a prosecutable offence. So people like me had currency notes in 1,000 and 500. We had come to the court and there was a potential prosecution which was being faced. So the Attorney General very fairly made a statement that as far as these petitioners with regard to the notes which they have disclosed, etc., because we made a disclosure in our petition of exactly how many notes we have, there will be no coercive steps which are taken against them. So this is now the background over here with respect to the orders passed by this court. Now just have a look at page 101. I'm not reading it beyond pointing out as to what. So just go to 100. Now this is your Lordship's Constitution Bench judgment rendered, as you will find at page 101 of the compilation, on 9th of August 1996, in the context of the Demonetization Act of 1978. Your Lordships have that? Now, this is again by a Constitution Bench, which your Lordships have noticed at page 101. I don't want to take your Lordships' time over this, except to say that apart from the issue which Mr. Chidambaram had pointed out with regard to the magnitude and whether this power can be exercised at all, the other element which the Constitution Bench did is, after examining whether the act and whether the action was constitutionally infirm or not, went into the individual cases of the writ petitions. I'm just pointing out, it happened before the Constitution Bench. Even though this was 18 years down the line, 1978, judgment eventually rendered in 1996, but the guardrails were set by the Constitution Bench at that point of time in the context of whatever was done way back in 1978, not dismissed as academic. And then for individual grievances, it was examined by the Constitution Bench, and you will find that, for example, at page 109, individual writ petitions by various cooperative banks, etc., and their grievances are examined and then dealt with by the Constitution Bench itself. So I would respectfully submit, now that your Lordships have a very good idea of how this matter progressed, how we are all before this court. Why? Because this court said don't go elsewhere and come here. Once this court says come here, once this court says it is to be decided by the Constitution Bench, to borrow your Lordship's expression, it then becomes the duty of the court to decide. Now, we are not insisting on whether it is to be decided today or tomorrow. But to shut us out and say that the issue is academic, as has been suggested by the other side, is according to us completely improper. Now, to answer that other point, there are, as you have seen from the, there are substantial questions which are framed, which are already there. Then you have two statutes. So may I just point those out from the compilation. Page 38, just have a look at 38. I'm not going to read anything. 38 is the ordinance which is subsequent to the framing of those questions. 38. This has the appointed date, clause 3, clause 4. And it came to be substituted by an act which is at page 53. So it becomes Act 2 of 2017.
Ramdevan,
Yes.
Just on fact.
Yes.
See, the earlier demonetization.
Correct.
You have seen Justice Mukherjee's judgment.
Yes.
Is it similar to the present one or it's different?
The answer is yes and no. The answer is yes, because it was, of course, a demonetization of currencies, etc., and a question of whether there was power under the RBI Act to do so. The answer, so to some extent, yes. So there will be some guidance to be obtained from that. But as Mr. Chidambaram mentioned a short while ago, in terms of texture, this is a very different situation because it's over 86% of the currency notes. So
What was the percentage earlier?
it was a very small 1.8%, very high denomination notes.
10,000 rupee notes and 5,000 rupee notes, which your Lordship remembers, 1978. Hardly anybody would have seen a 5,000 or a 10,000 rupee note. Today, you have demonetized 500 and 1,000. Somebody, my lord, Rip Van Winkle thinks that 500 and 1,000 are scarce notes. They are not scarce notes. They represented 86.6% by value. You have taken away 86.6% of the currency in circulation. Therefore, my lord, they are similar, as Ms. Devan said, similar but dissimilar. Your Lordship will get some guidance from Justice Mukherjee's judgment, but your Lordship will have to go further and examine the enormity of this demonetization.
Sorry. So, Manoj, just to.
The other thing perhaps, if I remember, those 10,000 rupee notes were very big, you know.
Hardly any, I have not seen the 10,000 rupee note.
I am assuming in those days.
They were large notes. They stopped issuing those notes long ago. There were some notes which were available. Similarly, the earlier demonetization also was a separate law, but that again was not the Mahatma Gandhi series, but the King George or whatever series. There were very few notes at that time in circulation, and therefore they said demonetizer. But you have taken away the bulk of the currency in circulation. And to say that this cannot be examined, this is economic policy. My Lord Justice Ramasubramanian's judgment is on cryptocurrency, virtual currency, policy of the government. RBI issued a circular. Your Lordships have held that the circular is illegal by testing it on the ground of proportionality. What else is cryptocurrency and virtual currency? It's an economic policy of the RBI. RBI said we will not allow virtual currency. That's an economic policy which the RBI is implementing through a circular. Your Lordship has struck it down on the ground of proportionality. Therefore, my Lord, your Lordships would have to hear us for some time even to come to the conclusion whether it's not academic. But we are confident we can satisfy your Lordship. The issues are not academic, they are very live issues.
I may add, Miller, to answer the query raised by Miller. So that, the earlier.
No, the Act is still in force. The Act
Yes,
is
of
still
course.
in force.
Yes, of course. The Act is a very.
The Act is still in force.
Yes. Yeah. And it.
Maybe I'm just.
So it is in force.
If they withdraw the Act, then repeal that, then perhaps it may become infructuous. Is it so?
No, Manoj, it still won't be so long as they give us value.
The Act is now occupying the field.
No. If you repeal the Act, probably then
it will be a different, story altogether. Why should we? Any one of us get into those hypothetical questions?
No, just.
I understand. These questions are bound to come. We're bound to answer them.
Well, one thing is the Act, the other is the notification of 8th of November. That notification of 8th of November is the one that is squarely challenged, apart from 24 and 26. The notification of 8th of
Mr.
November.
Chidambaram, notification is issued in exercise of what power?
Exercise of powers under section 26.
Of the Act.
Yes.
RBI.
RBI. All right.
So, Manoj, just to wind up, I might just indicate, in this compilation, you need not turn to it. We have also set out those impugned notifications. So they begin from page 31 onward, just for convenience. So that the notification, there is the Prime Minister's speech on 8th November 2016. There is the statutory notification at page 31. There is the Reserve Bank of India and the Press Information Bureau press statements which they have issued at pages 35 and 37. These are the subject matter of challenge, or to say that, look, we draw sustenance from these particular provisions. These provisions, speeches, etc., indicated that even after 31st of December, at our Reserve Bank of India branches, etc., there will be some specified branches, there will be facilities which were made which will be available. Then in this compilation, I've just placed it. I'm not going to take you to it. The facts as far as I am concerned. So I placed my writ petition which I had filed before this court. I was told that no, come with an intervention application, which is why I'm here before an intervention. I had left the country in April 2016. I returned in February 2017. When I had withdrawn some money. I'm telling you the real issue. This was hard-earned money which I had kept because I had to undergo a knee surgery or something, so I had kept it. I have all those deposits and those particulars. When I come back to the country in February 2017 and make a request that, look, please exchange these notes, etc., I am told, no, that can't be done. It's 1,62,000 as far as this particular party is concerned. It's very, very important. Hard-earned money, you cannot nullify it. So therefore, the constitutional elements come in. 300A, of course, 19(1)(g), 14, proportionality, and livelihood, which will come to, or life at any rate. But we'll deal with that at an appropriate stage. And the final thing which I'm just mentioning in this particular compilation, we've actually separately e-filed another compilation, but e-filing I've also given a physical copy. You needn't turn to this. Here, you needn't turn to it. But I want to just mention one thing, what the Reserve Bank of India said. The Reserve Bank of India said that on and up, that 16,000 crores worth of these notes, which are the specified bank notes, the value of which was specified, 16,000 crores worth was left outstanding. That is what their statement said on 30th August 2017.
What do you mean by
Before
that?
your
What do you
All
mean by
right.
that?
So what they said, so your lordship recalls that at the moment demonetization was announced, there was a window given for exchange of those notes,
Yes,
etc.
yes.
So basically it fell under two schemes. The Prime Minister very fairly said that, look, the last date is going to be in December 2016 itself. However, for appropriate cases, there will be some extension which is to be granted. That was obviously consistent with the government thinking and policy at that point of time. Thereafter, on 30th December 2016, they introduced an ordinance which said that, sorry, the last date is not going to be anywhere in 2017. It is going to be 31st December 2016 itself. And we are not going to allow any extension, though the ordinance provided for that provision under section 4, which this court asked the central government to file a reply that, look, are you planning to exercise this power under section 4 or not? So that's a separate issue. Now what happened? So to answer the question, what the Reserve Bank of India said is that all the currency notes which were cancelled, I'm just using the expression cancelled, or the specified bank notes of 500 and 1000, which they have received back, it constitutes 98.96% of the notes which were in circulation. But 16,000 crores worth of notes are still outside. This is Reserve Bank of India's statement. Out of that 16,000 crores worth, there may be some which are, which don't justify any leniency or any extension of benefits by the government because they may be unauthorized. So we are not talking. But in genuine cases like mine, where I was overseas, I came back, I have full disclosures. Even those people, in my case, 1,62,000 are completely shut out. So I'm left with holding these particular notes which are of no value. And thanks to the Attorney General's statement which he made, which I indicated to your lordships, we are not being prosecuted. Our notes are with us. We are before this court on this issue. Very important. It's not just some abstract principle. As far as I'm concerned, it's a question of my hard-earned money which has been rendered naught. So that's the issue. So, Manoj, these dimensions are far from academic. They are very, very much alive. Yeah. And Manoj, I think Mr. Chidambaram will have on the larger issues a lot further to say.
Your Lordship's last question.
Only,
Yes.
Shyam, you want
Yes,
for
yes.
Chidambaram starts. That money is still with you without any value, even.
Yes, exactly. It is still with me. And so the answer is yes. It is still with me. In my application now, I have given the specifics as to how many notes of 500. Requires a full hearing. I mean, brought us all to come over here and make these submissions. Now, please don't tell us that it is academic or send us back to some other court. Because your lordship, see, they move transfer petitions from across the country and wherever else. We've all come over here now and we waited. So now that your lordships are sitting on a panel of constitution bench, 5 judges, I would respectfully submit that. I mean, it's not going to take very long. I'm sure even on the merits, we will not be taking all the great lengths of time. And far from wasting the the time of the court, it's, I think, going to be very beneficial because the guardrails eventually are set out by this court as to what governments can do, what executives can do, and what they can't do. Grateful.
Only one interjection, my lord.
Yes.
Since, my lord, hard-earned money, this, that, and others, that is also taken care of by the Act Section 4. Possibly, there must have been application made and rejected. Possibly, we'll check up. So it's not that hard-earned money, my lord, is taken away.
Made and rejected, is it? Made and rejected.
Possibly, we will have to check up. So it's not as if hard-earned money of everyone goes. There are statutory protections given that you can convert it.
And
And the government, obviously, my lord, would be fully aware of this situation. I didn't want to interrupt, but he said hard-earned money taken away, that's not true. That's
To answer the submission that the 1978 Act, those writ petitions of individual cases were considered by the Constitution bench for good reasons. Kindly turn to page 109 of the order judgment of the Constitution bench. There was an appellate provision under the Act. Appeals were filed. Appeals were rejected. Thereafter they came to the court. Therefore they were heard again. So it's in an entirely different context, not because the petitions are being tagged along here, they have a right to be heard. So if the grievance
tagged to your instance.
the what I'm trying to point to there was a reason why they were heard.
Citizens have been tagged at your instance.
Because you didn't want it to face the music throughout the country, that's all.
There is very important reasons. Very important reasons.
But I was there, therefore I can say, not face the music. The idea was, there were conflicting orders being passed.
That's right.
Interim orders being passed. Therefore, we say that this is a pan-India issue, let the Supreme Court take it. That was the issue.
A matter of moment at that point of time. Therefore, the orders are being passed. So I come back to those 11 questions, the 9 questions. In my very humble submission, many of them are academic. I repeat that statement. If you look at this question, what's the scope of judicial review in matters relating to fiscal and economic policy? I mean, one more chapter to be added by this court in a matter like this. And then again, next question, whether a petition filed by a political party and the issue raised is maintained with Article 32, does it have any connection with this issue? Therefore, these issues probably are absolutely irrelevant to this point of time.
Mr.
So maybe
Attorney General, what at least we are thinking is, now the act is in force.
Yes.
The notification is still in force.
Yes.
The notification issued under section 24, right?
The act is taken over.
26 operated already. What is the correct way?
No, operated means it has come to an end, is it? Whether it is time bound, the notification.
Yes.
No, was it for a specified period?
Because
Yes.
certain consequence follows on 31st of December. That consequence is already
Therefore,
followed.
it has worked itself out.
Maybe we may
Therefore,
have to examine. We may
the
have
act
to
now
examine.
occupies the field.
We may have to examine, Mr. Attorney General.
But then I would probably advise the court that a limited threshold examination of what would be, if at all the court may have to go further in this matter. I thought a limited threshold examination.
What is
when
the prayer
essential
sought in the
core-
expedition?
Your Worship, please.
What is the prayer sought in, at least in
To
the,
set aside the notification.
exactly?
That's right.
That notification
Therefore,
is
today,
in force.
even if we set aside the notification, the act is in force. So therefore you can't have a, that's why it's an academic declaration.
No, in some of the petitions, the act has also been challenged. Act has been challenged, like 24 and
So it
26.
won't become academic in that sense.
And above all, we can only say academic or infructuous, because both sides agree. But if there is a point and a counterpoint, even to say whether it is infructuous, whether it is.
I quite see that. I quite see
that.
that, but only the concern is, before going into the larger canvas which persuaded the government to enter into this very important exercise. I mean, to lay down for the court all those very important considerations taken by the government. And it certainly
That is why
the court that
the earlier denotification, though, if I am right, it is 78, is it, or 76?
No, that was a-
It's not examined in which year? 92, is it?
96.
Years later.
We are the distinction between the 1978 Act and what's happening today is a very important distinction. A large number of developments in economic policy, banking policy, globalization, and impact of monetary policies across the globe. There is a large number of issues, corruption, black money, whole number of issues being taken into consideration by the government. Therefore, my only concern is to what extent the court will enter into all these
That of course we can decide only after hearing both of you. We are not able to make up our mind right now,
I understand. We are only trying
We are not
to
in a position to
You know, that argument is always available to you. What is the scope of our judicial review?
But
What are the limitations? So while examining their submissions, you will always be guided by those principles.
I'm not restricting that at all. I'm not saying that at all. But only saying that my concern is the moment you lost to get into any one of the issues, then there are further issues which keep cropping up. Therefore, I was trying to look at the issues. How many of them are academic today? Will the court go into all those issues at all? Probably that's why I said let's have some threshold for issues.
How can you say that?
Like to go into.
No, how can you say that issue number 7 is only academic?
No, it's not academic.
What is the scope of judicial review in matters relating to fiscal?
There are any number of your lordship's pronouncements on that. Any number of them.
Therefore,
Going back to your lordship.
Therefore, in order to answer that issue, we'll have to hear and give our answer to it and say whether it is academic or whether it is not academic or whether it is beyond the scope of judicial review. See,
Certainly.
the point is, as I already said, the government policy, the wisdom of the government is one aspect of the matter. We all always know where the Lakshman Rekha is. But the manner in which it is done, the procedure is something which can be examined and an answer can be given. But for that, it is necessary to hear the counsel, learned counsel.
Certainly, there is no resistance to that at all.
Yes.
I'm only repeating my concern that even the manner part of it, the procedural part of it. If the court may have to say, yes, the procedure was absolutely, inappropriate, ill-advised, then the court probably would enter into a domain where the wisdom of the procedure, followed would also be a matter for declaration by the court. Therefore, in that context, how far the court would travel?
No, any declaration.
How far the court would travel?
See,
Yeah, that's why these concerns are being flagged.
Any declaration one way or the other, is for posterity. And I feel it is the duty of the Constitution bench to answer it
Without
one way
doubt.
or the other.
Without doubt.
Yes.
But your lordships know that in certain momentous decisions taken by governments at given points of time, there are several considerations which are weighty persuasive.
Correct. While answering it, we would take into consideration those considerations.
But by only
We understand your apprehensions.
Lord, today your ladyship or my lords may not conclude anything. Let it be heard on some date.
Yes.
Without, my lord, any further orders today. Your lordships will not have the conspectus of the matter on both sides. We'll address your lordship.
know whether there is a point and a counterpoint which requires consideration.
Yeah. Yes.
So they should be satisfied.
Yes, my lord. He can have a suddenly and have no remedy. While taking that decision, even the hardship to be faced by honest people like Mr. Divan's client, they're also taken into consideration and provisions are.
Because your lordship will recollect that every exemption which is given under this scheme creates a huge impact. People try to take advantage of that exemption. So it was important to confine the exemption to very narrow limits. Otherwise, there has to be one cut-off.
All right, what we suggest is let Chidambaram make his submission and let us see, we will see after some time and we will grant you time, there is no problem. But let him make a beginning, let us see how things take shape, right? Mr. Chidambaram, please start.
But our response was the learned AG and me.
No, we will grant you enough time, nothing.
whatever I was trying to place your lordship, only with a certain amount of concern, you're opening a matter like this of large implication. We're not seen as, not inclined to assist, of course, that's not, but there are concerns which unfold over a period of time, which is a point I want to be very careful about it. That's all.
But we have answers, our affidavits are in detail and dealing with every submission, which we believe you will satisfy Lordship's conscience.
Yes.
Even they will not conclude today, probably only.
Yes, yes, yes.
The overview of them.
We will grant you enough time, nothing to worry. This can't be rushed through also, we know that
Yes,
also. But unless we make a beginning, how will you? Let us start, let us see. Yes, Mr. Sidhu.
Very well.
Yes.
I'm grateful.
Yes.
My Lord, let me indicate the scope of my arguments, broad overview of my arguments. And whenever your Lordship wishes to go into the questions more deeply, I will assist your Lordships. So the first question is, does the government have the power under Section 26 of the RBI Act to make the notification which was eventually made on 8th of November? 8th of November. In my submission, the government does not have the power. This was realized way back in
Mr. Chidambaram, before that,
Yes.
if you can give some sequence of events to understand better.
All right, I'll tell you.
Just the sequence, what happened on what day, just a few,
Well, there are only 3 events to our knowledge, and none of the documents pertaining to those 3 events have been produced, which is one of my complaints, which I will address. According to the record, according to the counter affidavit, and according to what is available in the public domain,
Yes.
on the 7th of November 2016, government wrote a letter to the Reserve Bank of India asking for its recommendation whether 500 rupee note and 1000 rupee notes may be demonetized. The starting point, according to the record, is the letter from the government to the RBI. The RBI board, my lord, your lordship knows, consists.
What exactly is the query to the RBI? What exactly?
Please make a recommendation
Ah.
whether 500 rupee note and 1000 rupee notes may be declared as no longer legal tender.
That was
This is
the
the letter from the government to the RBI. Much terms on that. On the 8th of November, the next day, the RBI did not take even 24 hours to consider the letter. The very next day, the RBI board meets in Delhi, not in Bombay. It meets in Delhi. The RBI board.
What is the significance? No, Bombay or Delhi, what is the significance?
Mr. Sharma, please maintain the decorum. Please maintain the decorum. No, please don't interrupt the proceedings like this.
Requesting that there will be one side only. I'm not saying anything. I'm saying only all the
You are interfering in the administration of justice.
they are extending just for nothing. And all the advocates, they are not only one advocate, they are all advocates are sitting and trying to see the court proceedings. They are helpless. Somebody should request them to be one side. That I am requesting them to be one side. Nothing more than that.
Oh, please, just simply disturbing.
Then I should take the assistance of Mr. Sharma.
See, for your information, we can't see the attorney from here, for your information.
I'll keep standing, your lordship.
No.
On the screen we can see one.
On the screen. There is no screen on the other side? No.
There is a screen, but I don't know whether.
Oh, that is covered.
No, that side they have a smaller screen.
There is a small screen here. There is a screen here.
Anyway, they hear it's sufficient, they need not see faces. Okay.
All of you are hearing, no, the discussion, all of you are hearing. What will you do, old people, by seeing us? All 60 plus men. No, I don't know. Sorry, I'm wrong.
Let the document demand.
What will you do by seeing us?
Now that
But everybody is standing over
vetted
there.
by television,
Everybody is standing over
wants to
there.
see everything.
Okay. All right. Yes, Mr.
I want only the judgment to be made.
All right. Please take your seat.
Say all the advocate do is telling just for nothing, he should
All
sit in
right.
fact.
Now you can hear, see, this is,
I will wear a mask and that will be a good decorum.
all of your VC links also.
Yes.
Of course, televised also.
Yes.
So that's
They can.
that explains why.
But when there is no.
I didn't want to say anything.
Can't be helped. Yes, sir.
Mr. Attorney, it means,
And this is not the first time a constitutional bench is heard. This is always like this, in the court,
Mr. Attorney, according to you, even if Sharma goes out, he can see the proceedings.
Yes.
He can see the proceedings wherever he is.
On the phone. Otherwise, if he is interested in seeing.
Wanted to get the BC reading, your lordship, I declined
Wherever he
in
is.
court martial, they mentioned before the court. I'm not well, I'm not well.
All
Not well.
right. What you want, VC link is it? You want, right now we will provide it. Please give it.
I'm not well, BC link is there, I have no objection, I
All
will.
right. What you want, VC link, please, you want, right
Court
now.
master declined, I give you my, they replied there, I have no objection. I show my reply, your lordship, her reply.
Please give him the link. Give him. Right now. you give him. All right. It will be done right
I
now.
show my reply.
All right. Now you take yours. Please give him the link. Yes, Mr. Chair. Right.
On 7th of November,
It will be done
the
right now.
government writes to the RBI
Now you take yours.
seeking its recommendation on whether 500 rupee note and 1000 rupee notes may be demarked.
Now you take.
On the 8th of November, less than 24 hours after the letter came, the RBI, which has its headquarters in Mumbai, its entire research staff, research department staff in Mumbai, does not meet in Mumbai, it meets in Delhi on the evening of 8th of November, according to information in the public domain. Does not meet the RBI board, my lord, ought to consist of 10 independent directors under section 8(1)(c), but 7 would consist of slots vacant
details for that YouTube video.
Please repeat. Out of.
out of 10 independent directors under 8(1)(c) of the RBI, only 3 were in place, 7 were vacant. They
At
are
the
not
bottom, you'll
filled.
see comments and ratings.
They are not
Select your
appointed
drop-down for
independent.
comment visibility.
The RBI board effectively consisted of the governor,
Comments and ratings.
the deputy governors, 4 deputy governors. The RBI board effectively 4 officers of the central government nominated to the central government, and under H1D, 2 government officials nominated to the central government. Central government are believed to have met in Delhi and under H1 and passed a resolution recommending 500
And then
rupee
here we
and
just would
1,000
say-
rupee notes may be demonetized. This was an 8th of resolution. That resolution or
This
recommendation.
was the statutory obligation, right?
Well, actually, the statutory obligation is the reverse. On the recommendation of the RBI, the government may deem demonetized. Here, it started with the government writing a letter to the RBI. RBI recommendation is transmitted to the cabinet. According to the information in the public domain, the cabinet is already meeting and it's waiting in the cabinet room. This recommendation comes to the government and this recommendation is accepted, and within minutes of the recommendation being received by the government makes the notification of 8th of November. And the Prime Minister, Honorable Prime Minister, goes on television at about 8 p.m. to announce demonetization while his cabinet colleagues are waiting in the cabinet room. They were requested to wait in the cabinet room. Question is, my lord, colleagues are waiting in the cabinet. My lady asked me, requested to wait. Is this the procedure contemplated in section 26? Assuming you're exercising your power bona fide under section, is this the procedure on matters so serious and so important? Assuming you're exercising your power demonetization, which will effectively take away 86.4% of the currency, can it be decided in a matter of 24 hours? Between 7th November, when the letter is received by the RBI, the board meets in Delhi, it is transmitted to the cabinet, and cabinet instantaneously accepts it. What is the application